here's how we're going to eat our vegetables. And this is going to kind of suck, but at the same time, it's a really important story that I think we have to cover.
Okay.
So, was it means tested?
Who has a gun to your head?
I read this story and I'm like, damn, man, nobody else is talking about this anywhere, but Kevin Gosztola dropped a banger. All right.
Okay.
And it's that the U.S. Supreme Court may take an aim at the whistleblower protection laws. And
could the Supreme Court do any worse this week? Any worse?
They're taking a wrecking ball to the rest of it. Yeah, Boudreaux, they gonna bring 10 million, them caters to 10 million better. Yep, that's right. Okay, so that's our friend Kevin Gosztola. Give him a shout, give him a subscribe, give him a follow, support the Dissenter, which is an offshoot of Shadowproof. It's his own personal newsletter that I also subscribe to. This is a paid article that I really thought was super important. Since I am a paid subscriber and I am a supporter, I don't feel so bad showing this to everybody. I did pay my money for this. All right. And I do support Kevin and I share a lot of his work, and I do encourage everybody to go follow at @KGosztola on Twitter. And he does unauthorized disclosure on Rockfin with Rania Kalik. Big fan of Rania too. And again, follow Shadowproof. He does that with Brian Sonnenstein. I'm a follower and a fan and a supporter of Shadowproof as well. They do excellent investigative journalism. They also report on prison stuff, prison treatments, and prison culture, and they do a really good job of that, as well as on whistleblowers. So Kevin has been following this story, and what he's saying is that the False Claims Act in the United States allows individuals with evidence of fraud against the government agencies to bring lawsuits as qui tam whistleblowers. I don't even know if I'm saying that right, but I'm going to keep saying it that way, and I'll probably butcher it. They can bring a case even if the Justice Department has no interest in fighting the alleged corruption. But on June 21st, Courthouse News reported that the U.S. Supreme Court will determine whether the government has the authority to dismiss a whistleblower lawsuit brought under the False Claims Act when the government has declined to intervene in the case. In other words, the Supreme Court can now help corporations shut down independent whistleblower lawsuits that the Justice Department does not want to pursue. What?
Yeah.
Okay. And guess who? Healthcare and pharmaceutical corporations, along with their lobbying networks, have ramped up pressure in recent years to stifle the effectiveness of the False Claims Act in holding their industry accountable and prevent the law's expansion. Shocking. Under President Trump, the National Whistleblower Center reported in 2018 that U.S. government recoveries under the law hit a 10-year low. Why? Nearly $2.9 billion was recovered, but only $767 million of that was a result of lawsuits by the government. Whistleblower lawsuits, however, yielded over $2.1 billion. Why? Because a network of dark money has transformed the Supreme Court into an illegitimate and partisan institution. It's a guy by the name of Leonard Leo in the Federalist Society. The same court that overturned Roe v. Wade, ending nearly 50 years of abortion rights, could gut one of the few laws available to private citizens to challenge corporate corruption. This
also took away the fact that they took away the right to. They said that natives' land is now the state's land.
Right, state lines now supersede native.
Yeah,
I don't know. So,
yeah, something like that.
We are pushing complicit government agencies to act. President Abraham Lincoln signed the first False Claims Act in 1863 during the U.S. Civil War. It became known as the Lincoln Law. Why? Because according to Tom Mueller, who was author of Crisis of Conscious Whistleblowing in an Age of Fraud, so he wrote a book about this, the law was intended to stop Army and Navy contractors from stealing taxpayer dollars, but also to push complacent or complicit government agencies to act. So if the government and the Justice Department wasn't acting, it was up to these private agencies or private citizens to bring this lawsuit against these corrupt contractors to the government. The U.S. did not have a Justice Department then, he noted, this Mueller. And I thought it was Robert Mueller, but it's not. It's the author. But what the Lincoln Law did was empower individuals to prosecute fraud with or without the government's participation. Offending contractors could be fined $2,000 for each misrepresentation or false claims that they made when requesting payment from the government. The law was gutted by Congress in 1943, because the Justice Department claimed that it didn't need the assistance of whistleblowers when prosecutors already knew about the fraud. And as Republican Senator Chuck Grassley recalled, this led to absurd results that only hurt the taxpayer. Well, of course he did. He's a corporate suck-up senator, right?
Yeah.
So Grassley, who's an advocate for the law, of course, said it basically meant that all whistleblower cases were blocked, even cases where the government only knew about the fraud because of the whistleblower. Well, that's no good. Right? In 1986, he helped to ensure that amendments to the False Claims Act were passed to restore power to private citizens to bring whistleblower lawsuits. That's a good thing. It ensured that whistleblowers would receive a reward in return for risking their career or legal jeopardy. However, in order to convince President Ronald Reagan to sign the amendments into law, Grassley and other senators had to overcome institutional opposition within the Justice Department. Well, of course they did, because they thought that they were taking away power from the Justice Department. Jay Stevens and Stuart Schiffer, two senior DOJ officials, opposed restoring the False Claims Act. Stevens contended that the Justice Department was already doing a good enough job against defense contractor fraud, and a stronger law would hamper their work, according to Mueller. The law, Stevens said, quote, was an anachronism from a time when the United States had no central investigative force. Now that the DOJ and the FBI existed, most qui tam whistleblowers were parasitic, quote, bounty hunters who interfered with legitimate law enforcers and ultimately provided little useful evidence of wrongdoing. Where'd this guy go to work after he left the government? I just wonder. The counter to Justice Department officials was that the restoration of the False Claims Act was necessary to protect whistleblowers from retaliation. The amendments were needed to prevent a complacent and complicit Justice Department from entering into sweetheart deals with powerful contractors. No, we've never seen that happen before, right?
No.
So what it's being presented as is a devastating threat to the executive's constitutional authority. The Justice Department officials remained opposed, even though Reagan declined to veto the amendments. In 1989, they argued to the U.S. Supreme Court that the law was unconstitutional.
Okay.
Here's a name you know, Bill Barr.
Yeah.
Who later became Attorney General under Trump, was the Assistant Attorney General at the time. He contended then that the False Claims Act represented a, quote, devastating threat to the executive's constitutional authority and to the doctrine of separation of powers, unquote. He objected to how Congress empowers citizens to help stimulate government action against fraud. Quote, there's been a massive upsurge in qui tam actions. Over 150 suits have been filed. Well, that's because there's been a mass upsurge in government corruption, you clown. These actions have disrupted the civil and criminal enforcement activities of the department. Yeah, because you're rife with corruption.
Oh.
They've also undermined the executive's ability to administer complex procurement contracts and in some cases have caused serious national security concerns.
Yeah.
Right? The 1986 amendments have also spawned the formation of full-time bounty hunting groups, ersatz departments of justice that go about prosecuting civil fraud actions in the name of the United States. So basically ambulance chasing lawyers who are looking for these fraud cases, and because there's so much of it, they're bringing these cases all day long and the Justice Department can't keep up. Well, guess what? The Justice Department can't keep up. Bill Barr was worried about groups representing whistleblowers who could collect up to 30% of any recovery because their effectiveness put the Justice Department to shame. He was ultimately unsuccessful in persuading the Supreme Court to neuter the False Claims Act at the time. However, 3 decades later, Barr was at it again in his position as Trump's Attorney General. The Justice Department dismissed an increased number of false claims cases for the reasons that Grassley believed had nothing to do with the merits of the cases. It seemed prosecutors were intent to discourage whistleblowers and undermine efforts to root out serious fraud. What a surprise. Why don't you, forget that ever happened now? All right? Bloomberg Law reported that the Justice Department moved to dismiss, quote, at least 14 cases involving pharmaceuticals. 11 of the cases were brought by the National Healthcare Analysis Group, which alleged violations of anti-kickback laws that prohibit improper marketing of drugs to medical professionals. They were viewed as a bounty hunting group, so we can't really pay attention to what they're doing. The National Whistleblower Center called attention, right? Go ahead.
It's just like the stuff they're willing to just say out loud is...
They don't care. Yeah,
anyway.
Again, who's stopping them?
I know.
This is the Attorney General. So
I know.
They're the authority in their mind, right? All right. So the National Whistleblower Center, called attention to the fact that the Justice Department was attempting to dismiss a case against the pharmaceutical corporation known as Gilead Sciences. A whistleblower accused the corporation of manufacturing drugs with contaminated ingredients from China, and unusually, the Justice Department maintained it would just be too costly to pursue the lawsuit. So it didn't.
China.
Grassley and a bipartisan group of senators tried in 2021 to correct the issue of dismissals by the Justice Department by creating a test. Prosecutors would be required to identify a valid government purpose and a rational relation between dismissal and accomplishment of that purpose. Right? So the whistleblower would then have the ability to challenge the dismissal by demonstrating that the dismissal was fraudulent, arbitrary, and capricious or illegal. But Big Pharma succeeded in blocking the amendments from inclusion in the 2021 infrastructure bill that passed. It was a major loss for whistleblowers. Fuck, dude.
Jesus Christ.
Quote, by raising false flags about these amendments and locking progress through complex and endless court cases, unquote, the National Whistleblower Center warned an anti-whistleblower victory, which could open the floodgates for future attacks on these highly successful whistleblower protections, were secured by lobbyists. And here's where we find out why. Record settlements and rewards under the False Claims Act. Here's where the donors are getting involved, and they're going, this ain't cool. During the past 5 years, lawsuits against the False Claims Act that are backed by corporate interests have sought to amplify uncertainty around the Supreme Court and lower courts' interpretation of provisions in the law. Each million spent on these efforts is intended to stall the progress of whistleblowers courageous enough to take a stand against corporate influence and power. I'm going to say that again. Each million spent on these efforts is intended to stall the progress of whistleblowers courageous enough to take a stand against corporate influence and power. GlaxoSmithKline, a major pharmaceutical corporation, was hit with a record $3 billion fine in 2012 after marketing their drugs for unauthorized uses and cheating the U.S. government's Medicaid program. The result was a whistleblower reward of $250 million, which 4 individuals split.
What the fuck?
Faced with allegations that it sold toxic mortgage-backed securities and other financial products in the run-up to the 2008 economic crash, Bank of America agreed to a record settlement with the U.S. government of $16.65 billion in 2014. 3 whistleblowers and 1 firm shared a $170 million reward in that case.
Jeez.
That's not 30%. That's like
no,
some odd percent. In this case, again, $3,250,000,000. That's not a third either. But they're still making nice coin. Now, people are getting angry, obviously, over the $170 million and the $250 million that's going to the individuals, and of course, the massive fines that's happening in the first place. Here's another one. Pharmaceutical giant Johnson & Johnson entered into a $2.2 billion settlement with the government in 2012 to end a lawsuit involving allegations related to fraud and kickback schemes perpetrated to sell 3 drugs, Risperdal, Natracor, and Invega. Vega. A whistleblower received a $167 million reward. Thank goodness for that. They deserve it. They put their entire life on the line. These are just 3 examples of how private individuals with evidence and knowledge of fraud can pursue a modest level of accountability against corporations, whether Justice Department officials have the political appetite for such action or not. The Justice Department says, their history of opposition to the False Claims Act does not exactly inspire confidence that the corporate-captured Supreme Court will leave the law alone. If the Supreme Court yet again prioritizes corporations and upends a settled law, their ruling may greatly diminish a tool that whistleblowers have wielded for decades.
Okay.
So,
well,
keep your eye on those guys.
Burn the fuck down.
Yeah, not cool. Not cool at all.
That's totally not going to cause problems in the future.
Right?
That's definitely not going to screw anything up.